Intellectual property law protects the creative and commercial value of ideas, inventions, artistic works, and brand identities. It is one of the most misunderstood areas of law precisely because the things it protects, works of the mind, seem different from physical property. People routinely violate copyright law without knowing it, assert fair use in situations where it does not apply, and confuse copyright, trademark, and patent as if they were the same thing. They are not. Each protects different kinds of intellectual assets for different periods of time under completely different legal frameworks. This is legal education, not legal advice. Consult a licensed attorney for guidance on your specific situation. Copyright protects original works of authorship, writing, music, film, art, software, architecture. The crucial thing most people do not know is that copyright protection is automatic upon creation. The moment you write a song, take a photograph, or write a paragraph, that work is protected by copyright. You do not need to register it, display the copyright symbol, or do anything special. Registration with the U.S. Copyright Office is required only if you want to sue someone for infringement. Registration is a prerequisite to filing a copyright lawsuit. Timely registration also entitles you to statutory damages up to $150,000 per infringement, rather than just actual damages, which makes registration strategically valuable even though it is not required for the copyright itself to exist. How long does copyright last? For works created after 1978, copyright lasts for the life of the author plus 70 years. For works made for hire, like content created by employees for their employers, copyright lasts for 95 years from publication or 120 years from creation, whichever expires first. Works published before 1928 are in the public domain. The public domain is a commons of works not protected by copyright, free for anyone to use. Works enter the public domain through copyright expiration, voluntary dedication, or government authorship. Works created by federal government employees as part of their duties are not copyrightable. The extension of copyright terms has been deeply controversial. Critics call it the Mickey Mouse Protection Act. Fair use is the most commonly misunderstood copyright doctrine. It allows use of copyrighted material without permission in certain circumstances, and courts evaluate it using 4 factors. The purpose and character of the use, commercial use weighs against fair use, transformative use weighs for it. The nature of the original work, factual works are more fair use-friendly than creative ones. The amount and substantiality of the portion used, and the effect on the market for the original work. The Supreme Court clarified the transformative use analysis in Campbell v. Acuff-Rose Music in 1994. Fair use is not a bright-line rule. It is a case-by-case balancing test, which means you cannot know in advance with certainty whether a use qualifies. The DMCA safe harbor protects platforms like YouTube from infringement liability for user-uploaded content if they respond promptly to take down notices. Trademark law protects brand identifiers, names, logos, slogans that distinguish goods or services from one source from those of another. Unlike copyright, trademark rights arise from use in commerce, not creation. The more widely a mark is used and the more distinctive it is, the stronger the trademark rights. Trademarks can last forever as long as they remain in use. Trademark infringement requires showing that consumers are likely to be confused about the source of goods or services. Patent law protects inventions. Utility patents last 20 years from application. Design patents last 15 years. Getting a patent requires the invention to be novel, non-obvious, and useful, and the application process is expensive and technical. Trade secrets protect valuable confidential business information without time limit, as long as reasonable secrecy is maintained. The Digital Millennium Copyright Act of 1998 fundamentally shaped the Internet's copyright landscape. Its safe harbor provisions, Section 512, protect platforms like YouTube, Reddit, and social media companies from being liable for infringing content uploaded by users, as long as the platforms respond promptly to take down notices and do not have knowledge of specific infringement. This enabled the user-generated content Internet as we know it. However, critics argue the notice and takedown system is widely abused, with false DMCA claims used to suppress legitimate criticism. The orphan works problem, where copyright-protected works have unknown or unlocatable owners, making licensing practically impossible, remains an unresolved gap in copyright law that prevents many historical and cultural works from being digitized and shared. This is legal education, not advice for your specific situation.